Welcome to our comprehensive guide on adjudication, special courts, the National Company Law Tribunal (NCLT) and the National Company Law Appellate Tribunal (NCLAT). In the world of corporate and economic laws, disputes are inevitable. The Companies Act 2013 has established a robust framework for resolving such disputes efficiently. In this video, we'll explore the mechanisms available for dispute resolution, the importance of NCLT and NCLAT. Before we dive into the detail, let's outline what you'll learn. By the end of this chapter, you'll know about various dispute resolution mechanisms, the significance of NCLT and NCLAT, and their appeal processes. You'll also understand the establishment and jurisdiction of special courts, the procedures for appeal and revision, the working of mediation and conciliation panel, and the process of compounding offences. Additionally, we'll cover the powers of the central government in a point. Dispute resolution mechanisms are essential for handling conflicts between parties in business or legal relationships. The Companies Act 2013 provides several forums for resolving such disputes, including the NCLT, NCLAT, Special Courts, the Serious Fraud Investigation Office, SPOM, a mediation and compounding panel. The establishment of these forums ensures that company-related disputes are resolved quickly and efficiently, reducing the burden. National Company Law Tribunal (NCLT) and the National Company Law Appellate Tribunal (NCLAT) were established to centralize the adjudication of company disputes. NCLT replaced several previous bodies, including the Company Law Board and the Board for Industrial and Financial Reconstruction. This consolidation streamlines the process, allowing for a single forum to handle all company law matters. The NCLT consists of judicial and technical members. Creation of NCLT and NCLAT faced constitutional challenges, particularly regarding the transfer of judicial power. The Supreme Court ultimately upheld the validity of these tribunals, with the caveat that certain qualification and selection procedures for technical members needed correction. This decision paved the way for the effective functioning of NCLT and NCLAT, ensuring that company law disputes could be handled by specialized forums with the necessary expertise. NCLT is a quasi-judicial body with a president and a mix of judicial and technical members. It has the authority to adjudicate all company law matters, including those previously handled by other boards. NCLAT serves as the appellate body for decisions made by NCLT. Both tribunals have powers similar to civil courts, such as summoning witnesses, requiring document production, and enforcing orders. This structure ensures that disputes are resolved by experts with a deep eye. Section 407 of the Companies Act 2013 defines the key members of NCLT and NCLAT. The chairperson leads the appellate tribunal, while the president heads the tribunal. Judicial members are appointed for their legal expertise, and technical members bring industry knowledge. These roles ensure that the tribunals are equipped to handle the complex and technical nature of company law disputes, blending legal acumen with practical business understanding. Section 420 outlines the process for issuing orders by the tribunal. Parties are given a reasonable opportunity to be heard before any order is passed. The tribunal can amend its orders within 2 years to correct mistakes, provided no appeal has been filed. Copies of all orders are sent to the concerned party. This process ensures fairness and transparency, allowing parties to seek rectification of errors while maintaining the integrity of the appeal process. If a party is dissatisfied with an order from the tribunal, they may appeal to the appellate tribunal (NCLAT) within 45 days of receiving the order. The appellate tribunal may grant an extension of up to 45 additional days if sufficient cause is shown. Appeals are not allowed for orders made with the consent of all parties. This structured appeal process ensures that grievances can be addressed efficiently while also preventing unnecessary delay. Both the tribunal and the appellate tribunal are required to dispose of cases as quickly as possible, ideally within 3 months of presentation. If a case cannot be resolved within this period, reasons for the delay must be recorded, and an extension of up to 90 days may be granted. This focus on speedy resolution helps maintain confidence in the system and ensures that justice is not delayed for companies and stakeholders. If a party is aggrieved by an order of the appellate tribunal, they may appeal to the Supreme Court within days on any question of law. The Supreme Court may allow an additional days if sufficient cause for delay is shown. This final level of appeal ensures that important legal questions can be reviewed at the highest judicial level, providing a comprehensive check on the decisions of the lower tribunal. Tribunals are not bound by the strict procedures of the Code of Civil Procedure 1900. Instead, they are guided by principles of natural justice and have the authority to regulate their own procedures. This flexibility allows for a more efficient and tailored approach to resolving company law disputes, ensuring that each case is handled fairly and appropriately. Tribunal and appellate tribunal have powers similar to those of a civil court. They can summon witnesses, require the production of documents, receive evidence on affidavits, and issue commissions for examination. Orders made by the tribunal can be enforced like court decrees, ensuring compliance and upholding the authority of these bodies in the corporate legal system. Tribunals have the same jurisdiction, powers, and authority in respect of contempt as the High Court. This means they can take action against anyone who disobeys their orders or shows disrespect to the tribunal. Such powers are crucial for maintaining the dignity and effectiveness of the dispute resolution process. Tribunal or appellate tribunal may delegate inquiries to officers or authorized persons. Additionally, actions taken in good faith by tribunal members, officers, or employees are protected from legal proceedings. This ensures that officials can perform their duties without fear of personal liability, provided they act honestly and within the law. In certain cases, such as winding up a company, the tribunal can request assistance from the chief metropolitan magistrate or district collector to take custody of company property or documents. This cooperation between judicial and administrative authorities ensures that tribunal orders are effectively implemented. Section 430 of the Companies Act 2013 bars civil courts from entertaining suits or proceedings on matters that fall within the jurisdiction of the tribunal or appellate tribunal. This exclusive jurisdiction prevents conflicting decisions and ensures that company law matters are handled by specialized forums. Vacancy or defect in the constitution of the tribunal or appellate tribunal does not invalidate its acts or proceedings. This provision ensures continuity and stability in the functioning of these bodies, even if there are temporary gaps in membership. Parties appearing before the tribunal or appellate tribunal may represent themselves or authorized professionals such as chartered accountants, company secretary, cost accountant, or legal practitioners. This flexibility allows parties to choose the best representation for their case, ensuring fair and effective advocacy. Provisions of the Limitation Act 1963 apply to proceedings or appeals before the tribunal or appellate tribunal. This ensures that cases are filed within prescribed time limits, promoting timely resolution and preventing stale claims from clogging the system. All matters pending before the Company Law Board or courts under the Companies Act 1956 are transferred to the tribunal. The tribunal disposes of these matters according to the provisions of the new Act. This transition ensures that ongoing cases are handled efficiently under the updated legal framework. Special courts are established by the central government to provide speedy trials for offences under the Companies Act, except those under Section 452. These courts consist of judges with the appropriate qualifications, such as session judges or metropolitan magistrates, depending on the severity of the offence. Their establishment ensures that company law offences are tried by experienced judicial officers. Special courts have jurisdiction over offences committed within the area where the company's registered office is located. If there are multiple special courts in the area, the High Court specifies which one will handle the case. This clear jurisdictional structure prevents confusion and ensures that cases are assigned efficiently. Special courts have the same powers as magistrates under the Code of Criminal Procedure 1973. They can authorize detention, take cognizance of offences directly, and conduct summary trial for less serious offences. This empowers them to handle company law offences swiftly and effectively, ensuring justice is delivered without unnecessary delay. Offences punishable with imprisonment up to 3 years, special courts may conduct summary trial. However, if it appears that a sentence exceeding 1 year may be necessary, the court will switch to a regular trial procedure. This flexibility allows for quick resolution of minor offences while ensuring due process for more serious cases. The High Court has the power to hear appeals, references, and revisions from decisions of special courts, as if the special court were a court of session. This appellate structure ensures that parties have recourse to higher judicial review, maintaining the integrity and fairness of the legal process. Less otherwise provided, the Code of Criminal Procedure 1973 applies to proceedings before special courts. For these purposes, special courts are deemed to be courts of session or magistrates, and prosecutors are considered public prosecutors. This alignment with established criminal procedure ensures consistency and legal certainty. Most offences under the Companies Act 2013 are non-cognizable, meaning police cannot arrest without a warrant or investigate without court permission. Exceptions exist for certain serious fraud cases. Courts can only take cognizance of offences based on written complaints from authorized persons, ensuring that prosecutions are not initiated frivolously. Certain offences under the Companies Act can be compounded, meaning they can be settled by paying a specified sum, avoiding prosecution. The tribunal or regional director handles compounding, depending on the maximum fine involved. However, offences punishable with imprisonment only or with both imprisonment and fine cannot be compounded. This process helps reduce litigation and encourages compliance. Compound an offence, an application is filed with the registrar, who forwards it to the tribunal or regional director. If the offence is compounded before prosecution, no prosecution is initiated. If compounded after prosecution has started, the court is notified and the accused is discharged. This streamlined process encourages early resolution of minor offenses. Central government maintains a panel of experts for mediation and conciliation. Parties to proceedings before the government, tribunal, or appellate tribunal can request mediation at any time. The panel aims to resolve disputes amicably and efficiently, reducing the burden on formal adjudication and fostering a cooperative approach to conflict resolution. Mediation and Conciliation Panel follows procedures set out in the Company Mediation and Conciliation Rule 2016. Matters referred to the panel must be resolved within 3 months and recommendations are sent to the referring authority. Parties dissatisfied with the recommendation can file objection, ensuring that mediation remains a voluntary and fair process. Serious Fraud Investigation Office (SFIO) is a specialized agency established by the central government to investigate serious fraud relating to company. Headed by a director and staffed with experts from various fields, SFIO investigates cases referred by the government, registrar, or based on public interest. Its role is crucial in tackling complex corporate frauds and ensuring accountability. The central government can appoint company prosecutors to conduct prosecution under the Companies Act. These prosecutors have the same powers as public prosecutors under the Code of Criminal Procedure, ensuring that cases are handled by qualified legal professionals with the authority to represent the government in court. Central government may direct the company prosecutor or authorize another person to appeal against an acquittal order passed by any court other than a high court. This ensures that erroneous acquittals can be challenged, maintaining the integrity of the judicial process and upholding the rule of law. Section 445 applies the provisions of Section 250 of the Code of Criminal Procedure to compensation for accusation without reasonable cause. If someone is falsely accused before a special court or court of session, they may be entitled to compensation, discouraging frivolous or malicious prosecution. Courts imposing fines under the Companies Act may direct that the fines be used to pay the cost of proceeding or as a reward to the person whose information led to the proceeding. This provision incentivizes whistleblowing and helps cover the costs of legal action, supporting the enforcement of company law. In deciding the amount of fine or imprisonment, courts consider factors such as the size of the company, nature of business, injury to public interest, nature of the default, and whether the default is repeated. This ensures that penalties are proportionate and fair, taking into account the specific circumstances of each case. One-person company, small company, startups, and producer company are subject to lesser penalties for non-compliance. The penalty is capped at half the specified amount, with maximum limits for companies and officers. This encourages entrepreneurship and recognizes the limited resources of smaller entities. Central government appoints adjudicating officers to impose penalties for non-compliance. The process includes issuing a show cause notice, allowing replies, and providing an opportunity for a hearing. Orders are passed with reasons recorded, and copies are sent to all concerned parties. This structured process ensures transparency and accountability in penalty adjudication. Anyone aggrieved by an order of the adjudicating officer can appeal to the regional director within days. The regional director reviews the case, hears the parties, and may confirm, modify, or set aside the order. This appellate mechanism ensures that penalty decisions are subject to review and correction if necessary. If a company or its officers fail to comply with penalty orders within 90 days, they face additional fine or imprisonment. This enforcement mechanism ensures that penalties are not ignored and that compliance with the law is maintained. If a company or officer repeats a default within 3 years of a previous penalty, the penalty for the subsequent default is doubled. This provision acts as a deterrent against repeated violations and encourages sustained compliance with the Companies Act. Throughout the Companies Act 2013, several case studies illustrate the application of these provisions. For example, the Z Entertainment case highlighted the importance of giving parties sufficient time to respond, while the Union Bank of India case clarified the transfer of winding up proceeding to NCLT. These real-world examples help us understand how the law operates in practice. Summary: the Companies Act 2013 provides a comprehensive framework for adjudication, dispute resolution, and enforcement in the corporate sector. The establishment of NCLT, NCLAT, special courts, and supporting mechanisms ensures that company law disputes are resolved efficiently, fairly, and with specialized expertise. By understanding these processes, companies and stakeholders can better navigate the legal landscape and uphold good corporate governance.